Hi, I'm Tyler Danzel, and this is Module 13, Tort Liability. Definition of tort liability. First of all, let's define what a tort is. Nathan Ethics, the author of our text for this class, defines tort as an actionable wrong committed against another, independent of contract, or a civil wrong. Black's Law Dictionary defines tort as a civil wrong for which a remedy may be obtained, usually in the form of damages. And finally, the lawdictionary.com defines tort liability as the obligation legally of one party to the victim resulting from a civil wrong or injury. So the first case that I chose to discuss was Doe versus McLean County Unit District number 5. John White was a teacher who taught in 2 different Illinois school districts, and he was accused of sexually abusing girls in both districts. So McLean County was the first district that White taught in, and he left there and was actually recommended by McLean County for a job in the Urbana School District. And so he was being sued, saying that the abuse that occurred in the second district was actually caused by McLean County. The trial court initially ruled in favor of the McLean County Unit District. However, the Illinois Supreme Court reversed that decision, and White is currently serving a 60-year prison term after pleading guilty to multiple charges of sexual abuse. Some reactive measures. If I were in charge at McLean County, I would determine who recommended this teacher for a new job. They would be placed on administrative leave, and we would do our best to terminate their employment, because things like this cannot happen. Some proactive measures, we would try to make sure we have good policies in place and procedures on how we would handle sexual abuse allegations against a teacher. The second case I chose was Mitchell versus Cedar Rapids Community School District. What happened in this case was a special education student was sexually assaulted by another student, and so the mother sued the school district. What was interesting about this was the assault actually took place after school hours and off campus. However, the student had left school without the school knowing, without her parents knowing. It was an unexcused absence, but the school did not notify the parents. A jury found the school district negligent, saying they failed to adequately supervise the student. So some measures. First of all, there would need to be strict policies in place that require the notification of the parents when a student is in the middle of an unexcused absence. Ideally, this would be automated with technology of some kind. Proactive measures, very similar. Again, there needs to be policies in place that require the notification of parents. Again, technology would be nice in this case, but also require teachers to submit attendance at the very beginning of class. The next case was Johnson & Johnson versus School District of Millard. What happened in this case was a first grade student was injured in music class while participating in activity related to the song London Bridge is Falling Down. The student was thrown into a bookcase and sustained a cut that was very extensive. The teacher actually did not see the incident because she was aiding another student in the activity. The court ruled in favor of the student and his family. They said the teacher was negligent in their supervision, and the family was awarded over $20,000. Some reactive measures in this: create a policy, this is going to sound a little silly, but create a policy that eliminates physical contact between students during class. Obviously, PE classes would need to be exempted from this policy. Also, I would meet with our teaching staff, explain to them what happened in this incident, and have them do their best to prevent it from happening again. Some proactive measures: encourage teachers to use discretion and good judgment when they are choosing activities for their classes, and obviously avoid activities that could foreseeably injure a student. Next was Frame versus Camo. Casey Frame was an 8th grade student at a school and there was a substitute teacher in his class, Dr. Barry Camo, and Casey Frame was alleging that assault and battery took place by the substitute teacher. Basically, Camo forcefully removed Frame from the classroom because he and other students had been disrupting the spelling test that was being administered. The court ruled in favor of Camo. They did say that he committed battery but was justified in doing so, and his actions were necessary to maintain order and to help facilitate the learning process. Some reactive measures: remind teachers to refrain from touching students, except in the most dire situations. If a school resource officer is not already in place, that might be a nice thing to have to deal with incidents like this. Some proactive measures, kind of similar: implement procedures on how to remove disruptive students. Again, have school resource officers in place, and encourage teachers to refrain from touching students. The final case that I chose was Flanagan versus Canton Central School District. Flanagan's mother sued the school district because her son sustained injuries in the locker room after PE class. The students in this particular class that day had been especially rowdy, and the teacher had stayed outside the locker room to visit with one of those students and did not supervise the locker room as he normally did. The court sided with Flanagan, basically saying the teacher was negligent in his supervision. It was also foreseeable that this could have happened based on the behavior of the students on that particular day. So reactive measures, both reactive and proactive, are going to be very similar and are fairly simple compared to the other cases that I've chosen. Basically, the locker room needs to be supervised, and if policies are not already in place for that, they need to be. In summary, it's going to be very difficult to prevent all torts that could happen in a school. Creating a code of conduct for staff will help, but will not eliminate all things, especially when you consider the case of the student who was sexually assaulted off campus and in non-school hours. But just encourage staff to be professional and to use good judgment at all times. Thank you.